Um, Good afternoon, everyone, and thank you for joining our today's postdoctoral affairs seminar series. And this seminar series topics are based on our postdoctoral association and request of our postdoctoral fellows. And today's topic is immigration education and status maintenance. So all we are international, our student and postdoc, we all know that immigration status maintenance is as critical as our research. So, and having a good knowledge well in time is the key of our success. So, our today's guest speaker invited was Mr. Ashley Wallace, who is Director for International Students and Scholar Service at UTSA. So most probably all of you know him because he is your first point of contact when you arrive to UTSA. And Mr. Shahid Malik, who is an immigration lawyer. He is here today to guide you all for not only to educate you for the knowledge, but also to change your status because most of our postdocs wants to go for green card or citizenship at later. So thank you both, Mr. Wallace and Mr. Malik, to join us here and share your knowledge with our student and postdocs. And thank you, and go ahead.
Thank you, Dr. Joshi.
Thank you.
Good afternoon, everyone. My name is Ashley Wallace. I'm the Director, International Student and Scholar Services. I will be with UTSA 11 years, April 1st. All 11 years have been in the international office. A little bit about myself, came to the United States as a 16-year-old on an F1 student visa, and then have transitioned to green card, and most recently became a US citizen about 2.5, 3 years ago. So kind of lived the immigration life personally and professionally. And I'm excited to answer questions that you all have today. If you have questions about the F1, the J1, maybe some academic H1B questions, happy to answer those. And I'll pass it over to Shahid to introduce himself.
Thank you, Ashley, and thank you, Dr. Joshi. Ashley, could you share give me the sharing ability for my slides? Good afternoon, you guys. Thank you all for joining us and taking time out of your lunch hour. My name is Shahid Malik. I'm an attorney that specializes in immigration law. I've been an attorney since 2007, 2008. Been representing UTSA since about 2015. I think we're going on almost 10 years now. I handle the permanent residency options, and we work together with Ashley and all the departments. And let me get my slides going here. And just to tell you a little bit more. Yes, I'm good. I'm just finding my file, and there it is. So while I'm getting this going, let me just keep talking. So like I said, I've been practicing for about 15 years, representing UTSA for about 10. And okay, can you all see this?
Yes, sir.
Okay, so just to tell you about myself, give a brief introduction. So I'm board certified in immigration law by the Texas Board of Specialization. I'm also on the committee that writes the exam for other attorneys in the state of Texas to become board certified. Myself and my business partner, Andres Perez, are on this commission. We're 2 of 9. And so we eat, breathe, sleep immigration law all day, every day, basically. So we can help you. As part of our arrangement with UTSA, we offer free consultations with anybody associated with UTSA, essentially. So here's our email, here's the phone number, write it down, take a screenshot, take a picture, give us a call, schedule an appointment with me. You may have detailed questions that we may not have time for in today's session. That's only 1 hour. But I'm happy to schedule a consultation with you one-on-one at no cost, and we can discuss all your questions. Disclaimer that we as attorneys got to give. I'm not your attorney yet. Everything here in this presentation is just information and not legal advice. Okay. That being said, topics that Ashley and I will cover today include a lot of this. So Ashley's going to touch on maintenance of status, and I think I'm going to answer questions on how to get a green card essentially after that. But given our cozy group today, we can do whatever you guys want. We can talk about anything, immigration. We can just make it Q&A. I'm open for any style that you guys want. The point is to be very informative and answer your questions. What do you think, Ashley?
Yeah, I think that's good.
Do you want to start it off, Ashley? Just briefly touch on what maintenance of status means, and we can open the floor to questions.
Yeah, I can just give a brief overview of J1, F1. I don't think I even need to do my slides. I can just talk about it.
Okay.
So for everyone that's here that's on a J1 visa, so most likely you're here as either a research scholar, short-term scholar, or professor category. The professor category and the research scholar are interchangeable. So for example, if you initially come to the US to participate as a postdoc and most of your focus is on research, then you're going to be designated as a research scholar. If that were to change, and let's say you got an appointment by your department to teach some classes and the teaching component became more than 50%, then we can interchange that J1 category designation to the professor category. It's the only J1 categories that can be interchanged. The others cannot be. The maximum stay that you can have as a J1 research scholar, J1 professor is up to 5 years in the United States. At that point, you would have exhausted your eligibility to remain as a J1. If you're interested in staying in the United States beyond the 5 year for the J1, you could either change your status to that of a student. Maybe you get admitted into a PhD program at UTSA. And if you're not subject to the 2 year home residency requirement, you could apply for what's called a change of status inside the United States by filing a petition with USCIS, which is United States Citizenship Immigration Services, branch of the federal government. Also, there's a short-term scholar option. So some of you that are only coming here for a short stay, the short-term scholar option is a great category for J1s because the maximum stay is up to 6 months. But you're not going to be subject to the 2 year home residency requirement because of the short-term nature of the program. The only thing about that J1 short-term scholar is if you have some delays in your research and need to stay beyond the 6 months, it's not going to be possible with that category. So if you wanted to stay longer, essentially you would have to depart the United States, get a new DS 2019, which is the immigration document that you use at the US Embassy to apply for the J1 visa, to come back again either as a short-term scholar or maybe come back as a research scholar if you need more than 6 months. Other important things to remember about the J1 category is that if you do need an extension of your program, it is important to initiate that process with your department that is hosting here at UTSA and with myself before your DS 2019 expires. Failure to do so makes it very difficult for us to extend your program, as essentially that would be a violation of the J1 status. So I would highly recommend that if you know you need an extension, initiate that process about a month or so before your DS 2019 expires. Again, DS 2019 expires, not the visa, because your visa might have already expired. And if it has, that is perfectly fine. Only need a valid visa to enter the United States. So it can be expired while you're here. The important documents to understand is the DS 2019 and your I-94 once you're inside the United States. Other important things to remember about the J1, and also the same with the F1 status, is that if you have a change of address, you need to report that to me or to my office within 10 days of that change, as then we are required to report that to Homeland Security within 21 days. Also, if you're planning on traveling, so maybe with spring break coming up next week, some of you might be thinking about departing the United States for a period of a week or so. then that's perfectly fine. Just let me know or let Riel know in my office, and we'll be happy to sign either your F1 Form I-20 or your DS-2019 if you're on a J1 visa. And that way, it'll make your return to the United States much smoother going through the port of entry, as we are basically validating your status, verifying to immigration that you are in compliance with all rules, regulations pertaining to your F1 or J1 visa type. Also, important thing to remember about the J1, some of you may be subject to the 2-year home residency requirement. And if your DS 2019 does not have it indicated, your visa will have it indicated. And the visa notation supersedes the DS 2019. Sometimes the embassy might stamp you as not subject, but the visa will say that you are subject. If that's the case, the visa supersedes what is listed on the DS 2019. Why is the 2-year home residency important? Important for a few reasons. If you are subject, that means that you are unable to apply for a change of status inside the United States. That is a change of status to any other visa type. Also would limit you as far as H-1B and L-1 visa as well. You would not be able to get an H-1 or an L-1 even if you do it outside the United States until you've either satisfied the 2-year home residency requirement in your home country or have applied for a waiver through the U.S. Department of State. Also, it will prevent a green card application, which Shahid will touch on later as well. But if you're not subject to the 2-year home residency requirement, some of you I know are not, then you have more options as far as you can change your status inside the United States. You are not restricted on the L1 or the H-1B or the green card options if they're available to you. So definitely, it's a good idea to always be checking your documents, make sure that everything that you have is accurate. And if you have questions on that, please feel free to reach out to me. We are happy to assist you with anything that you need. I'm going to do a little bit here about the F1 because I know we have a few F1s as well in the group today.
And actually,
The
we do have a
F1 kind of
question.
similar, that as far as the expiration date goes, if you know that you're not going to graduate by the end date listed on your I-20, then it is important to initiate that process with our office at least a month or so before you expire. Sometimes, you might get into difficulties with your research, which is preventing you from completing your dissertation. That's normal, it happens, but we can help you with the extension if needed. Also, if you already have graduated and are on optional practical training, so you're on the initial post-completion OPT, 1-year employment authorization, the EAD card is your important document now, as that legally will tell you the end date of your employment. So you cannot work beyond that end date. Now, if you are a student in a STEM field, you can apply for what is called the OPT STEM extension up to 90 days before your current EAD card expires. That if you apply for the STEM extension, it'll give you 2 additional years of employment in the United States, providing it is with an E-verified employer, and it is a paid position. No volunteer positions qualify for STEM. And also keep in mind that if your EAD card has expired and you are STEM eligible, you no longer have the opportunity to file for the STEM extension. It must be filed and receipted prior to the EAD card end date. If you were to file it even a week or two before the EAD card expires, it is considered timely filed, and USCIS will grant you a 180-day grace period to continue working in the United States with the expired EAD card, which is really good. So that way you can continue working. There's no need to file with premium processing, as most likely it'll be approved within anywhere from 60 to 100 days or so. And I'll be very honest with you all, students who have applied for OPT in the last 2 weeks, so the students who are graduating this semester, students who have filed for STEM have been getting their approvals in less than 3 weeks without premium processing. So now is the time to file. File early is always recommended. That way you'll get the best of USCIS processing times, because the later that you wait, the longer it's going to take, because more and more students throughout the United States will graduate in May, potentially also summer graduates in August, so that will increase processing times. So if you know that you're going to graduate, I would highly recommend initiate the process as soon as you can, up to 90 days before the I-20 end date. And I think that's pretty much everything that I have on the F1 and J1. I can pass it over to Shahid, and then I can answer some questions as well at the end if you all have anything about any of the non-immigrant statuses that we can help you with.
Thank you, Ashley. We do have one question from Sahil. What I'll do first is just introduce the different green card options, and then we can go back to answering questions. Does everybody here? I guess you guys can use the chat box, but I'm gonna assume everybody knows what EB2, EB1 means, just from the two questions we've had so far. But if you don't, it just stands for employment-based 1, employment-based 2. Typically, the higher the category, the quicker the green card comes. The weight of the green card is determined by country of birth and by the category you're in. And so I'm gonna put up a slide here real quick, and it looks very complicated and confusing. And I think that the government makes it that way on purpose sometimes. But this is the family-based one, and similarly, there's an employment-based one, and it's broken down by the country of birth. But basically, all you need to take away with it is if you're born in India or China, generally speaking, you do not want to be in EB2 or EB3 because the wait time is too long, so long. But it's not the worst thing in the world. But if you can get into EB1, it's preferable. Okay, so what do you need to get into these different categories? And so this slide right here is a brief introduction on the process. It's multiple steps. There's a petition called an I-140 that is filed before the green card can be filed. And the I-140 is typically filed by the employer. There's a couple of categories where an employer is not required, and that just means you self-file the I-140. Once the I-140 is approved, it's just classification. It classifies you into EB1, EB2, EB3, etc. Okay. As it pertains to most of you, higher education has specific options available. Okay. In the EB1B category, there is a category just for internationally recognized outstanding professors or researchers. Okay. This is a great category. It requires employment sponsorship. You cannot self-sponsor. Okay. And the other category, you need to be either, and by other category, I mean researcher or professor. So if you're a professor, your job duties must involve teaching, and you must have 3 years of experience, and you need a job offer that's tenured or tenured track. And all of that is the same if you are a researcher, except the teaching and tenure requirement. So again, you need a job offer, you must be a researcher or professor, and you must have 3 years of experience. And if you're teaching, then it must be tenured or tenured track. Then you must also show that you have 2 out of 6 qualifiers, 2 out of 6 factors, and these are those 6 factors. These apply to both teaching and researching. Okay, so I'm not going to go into the details of these, just for brevity. The EB1A category is called extraordinary ability, and this category does not require a job offer, but it does require that you're the best of the best, top 10% in the world in your endeavor. The obvious ones are Olympic medalists, Nobel Peace Prize winners, things like that. But you don't need to be that great. You only have to demonstrate 3 out of 10 factors. Again, this one does not require a job offer from an employer. Okay, and then in the EB2 world, excuse me, there's something called a perm. A perm US-based green card. PERM is an acronym, and it's by the US Department of Labor. And in a nutshell, if you're a non-higher education private employer, or just any run-of-the-mill position that's not higher education, for example, you're working as a programmer for Microsoft, or you're an accountant somewhere, in order for you to go from H-1B or even OPT or whatever status you're on to green card, the company would prove first that there are no qualified, willing, and able US workers to do the job that they want you to do, and then you can get a green card that way. There is a easier, softer version for higher education if and only if your job offer involves teaching, and we call that special recruitment perm. And a special recruitment perm is softer or easier because you don't have to prove that there are no other employees available, but UTSA only need to prove that you were the best qualified amongst all the applicants. This is a EB2 category. And so if you're born in India, the wait time is a good 10 years. If you're born in mainland China, it's a good 5 years or so. So again, EB1 is more desirable. Sometimes you have to do an EB2 case if you are on H-1B. And as far as your maintenance of status goes, which is the topic of today's session, you know that you have 6 total years on H-1B, and then you're done, unless you can get an I-140 approved. In that circumstance, you can get your H-1B extended beyond the 6-year limit. Later, when you're more qualified, or when the opportunity arises, you can upgrade your case from EB2 to EB1 by filing a new I-140, and you get to keep your place in line from the old I-140. Okay. Also in the EB2 world, we have something called national interest waiver and exceptional ability categories. The national interest waiver does not require you to have an employer sponsor you. So when it says waiver, what do they mean by that? What does waiver mean? And so what is that? What it means is it's a waiving of the requirement that you have an employer to prove that there were no other US workers available. It's simply a waiver of their perm requirement. Okay. To be able to even be considered for this type of case, you must have at least a master's degree, which I'm sure all of you do. And at that point, next, you must prove that you have an endeavor. Endeavor is a key legal term. An endeavor is more than just a job. It's more than just an occupation, but it's your kind of like your calling. What are you doing in your career in life? And then you must show that you have a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. Okay. And then overall, the idea here is you have to show that you are in the national interest of the US, and therefore the employer need not, or they're not even need be an employer. But if there was, they don't need to prove that there's no other US workers to do the job that they want you to do because you're in the national interest. Okay. National does not mean federal in scope, does not mean to the USA government. In other words, it could be to a state government, to the state of Texas, to the state of Florida, etc. It could even be to a city or a county, and it's up to you to define that and convince immigration that you qualify. And there's also qualifiers, and these are some of the qualifiers. Very similar to EB1B almost, except it has the qualifying factor of national interest as opposed to recognized as outstanding. Okay. Typically, if you qualify for the NIW, then you will qualify for the EB1B, but you need a job offer and you need the minimum requirements of the tenure track if you're teaching. And if you're not teaching, then you just need to do doing the research. Okay. These are some more of the qualifiers for NIW. Okay, so we do have a question from Sahil. Sahil's question is, I would like to know more about the EB2A category as it pertains to me in EOPS higher education, higher ed administration program working on research. My take was to publish and use that as a qualifier for filing. Can you please shed some light on this topic? Okay, so Sahil, in this situation, I'm guessing the EB2A you're referencing must be some type of so the EB2A is usually the perm case, but I don't think you're talking about perm when you mentioned publications. I think you're talking about either the NIW or the exceptional ability. But yes, publications are kind of central when you are a researcher. And so the analysis will begin like this. What are you doing now? Do you have a J? Are you subject to the 2-year foreign residency requirement or not? If you are, you will need to eventually get that waived. There's different kinds of waivers. We'll come back to that. And if you're not subject to the 2-year foreign residency requirement, then you can proceed to your next non-immigrant visa, which could be H-1B, O-1A, and then let's pretend you're on H-1B and you have the 6-year time frame that you must get an I-140 approved within and file a green card essentially. Otherwise, your H-1B expires and you'll run out of the 6-year time frame. And so you would essentially go from J to H-1B, and then while you're working on your H-1B employment, in the background, in a parallel process, you begin your I-140 case. And let's just pretend that that's a national interest waiver case. You file the I-140 with all your supporting evidence, and in this case, your publications would be kind of focused, centrally focused on. Alternative to the NIW case, if you do have a job offer, let's pretend as a research associate at either a private company or a university, they can file your case for you. They file your I-140 on your behalf. And then you want to focus on the EB1B category so that you can get out of the EB2 category. Okay. Now, if you're not born in India or China, a green card is a green card is a green card. It doesn't matter which category you're in. And you want to take the path of least resistance. What's the easiest way with the least challenge by immigration to get approved? And there's no one size fits all for this type of question. That would be something that I would, talk to you about and look at your CV and see what I think. And some other factors, maybe you have a spouse, maybe you have children, just a big picture that goes into that. Okay. It's also important to note if you are born in country A, for purposes of determining your green card wait time, you can use the country of birth of your spouse. So Sahil, I see you're from India. So if you happen to be married to somebody from Mexico, you can use your wife's country of birth to get around your long wait time. So this is what we call the visa bulletin for employment-based categories. And this is from November 2022. And you see there's some countries at the top and some categories on the left. And the countries on the top are your countries of birth. If you were born in one of those countries, then you use that column. And then you align it with the row for what category you're in. And you see EB1, employment-based category 1, it all says CCC. C means current. That means today there is a green card ready for you. There is no line. If there is a date on here, that means if you got in line on that date, today there is a green card available for you. How do you get in line? Typically, you have to file the I-140, and on the day it's filed, you're in line. And if you're doing a perm related case, then the date the perm is filed is your date in line. And so you see in India and China, there's long wait times in EB2 and EB3, but typically not in EB1. And that, although it's different today, it holds that same premise that China and India take longer. And you may be wondering why? Why do they punish China and India? And it's not really a punishment. It's just the way that our laws are drafted by Congress from decades ago. And the U.S. immigration system puts a governor on giving new green cards based on the country of birth. And so if more people apply from your country, well, the line's going to be longer for you. And so it splits it up into per country. So India and China send the US many immigrants. And so consequently, the wait time is longer. And the family side, Mexico is the anomaly. And if you're born in Mexico and you're doing a family-based petition, maybe from your brother or sister, the wait time is tremendous, like 20 years. And that's unfortunately just the way our immigration system is. And our job is just to navigate around it and find the best option available. One other thing I wanted to add to Ashley's presentation, if you have a situation where your DS form says you're not subject to the foreign residency requirement, but your visa says that it is, and Ashley is correct, the visa would supersede it, but it could be that whoever created that visa made a mistake. And so there are ways to challenge that if you believe it's wrong. We can make a legal challenge with the Department of State and present that to USCIS. And ultimately, when you're adjusting status here, it'll be USCIS and not the Department of State that would make the determination whether you're subject or not to the 2-year foreign residency requirement. I want to say in the past 15 years, I've only had about 5 cases where it was erroneous. But when it is erroneous, it's such a relief because now you have that off your back and it's not really a waiver. It's just a correction of an incorrection. Okay. Let's see. When the waivers, after your green card, 5 years after your green card, you can get citizenship. Once you get citizenship, you have a U.S. passport, and you can file for other family members, such as brothers, sisters, spouse, children, parents. And I'm waiting for more questions. Please type your questions in the chat box, and I'd be happy to answer your questions. These are other ways to get green cards that are not by employment. If you're married to a U.S. citizen or even a green card holder, we can file green cards for you. Hopefully you're not getting deported in court, but if you are, the judge can get you a green card. Victims of crime, if you ever are a victim of crime, you can get a green card that way if you help the police and then they turn around and help you with your green card application. Victims of domestic violence, VAWA, Violence Against Women's Act. Okay. Let's see. Yeah, Ashley says a J1 waiver. You may request an advisory opinion. That's exactly right. If you ever have a belief that you're not subject to it or you are, and one way or the other, that's the way to do it. Thank you, Ashley.
You're welcome.
Any other questions?
Shahid, would you like to cover a little bit about like industry H-1Bs? Because I know some may not go academic route and might
Sure.
look for industry since they can only file certain times of the year.
Yes, that's right. So industry H-1Bs. So the first thing to understand is why is Ashley making a distinction between industry and higher education? And the reason is there are a finite number of H-1Bs that the US government makes available each year, unless your job offer is from a university or some type of higher education or nonprofit research agency. And that just means that if you are getting an H-1B filed by a university, it can be filed anytime. It's very lenient. However, if you're going to go work for Microsoft, then you can't just hop on anytime you want at the beginning. And so every year, once a year, the government immigration makes available a finite number of H-1Bs, and that number is 65,000 each year. And there's an additional 20,000 if you have a master's degree from the USA. And every year there's a lottery because there are 300, 400,000 applicants, and there are only 65,000 or 85,000 slots available. And because of that, you must get registered into the lottery. And the lottery is held every year. this month in March. In fact, it opens on Wednesday and it's available for 2 or 3 weeks. And so this Wednesday, March 6th, is when this lottery opens, and the process for your prospective employer is to register you for the lottery. And it's a very formalized process. It's online, and it's a very formal process. After the registration is completed, immigration in early April holds a lottery, and they let you know sometime in April, or usually a few weeks into April, did you win the lottery or not? Okay. Meanwhile, you presumably are on OPT, working for that employer or not. And if you are and your OPT is expiring, then you need to take action. So on H-1Bs, once you were selected in the lottery, the next step is to get your employer to actually file the H-1B petition on your behalf. Once it's filed, you'll get a receipt, and you need to let your DSO at your school know that it's been filed, because they need to make a record in your CBIS record. Once the H-1B is approved, it can't be approved any sooner than October 1. October 1 of the year is the soonest it can be approved. That means the soonest you can be on H-1B is October 1. What happens if your OPT expires before October 1? That's okay. That's called cap gap relief in the law. There's a section, and it says if your OPT expires before October 1, then we will automatically extend your H-1B status to October 1, the date that your H-1B begins. It's important during this time. Again, you let the school know, and you not leave the USA, because you're not going to be able to get back in, most likely, until October 1 on H-1B status. And if you do leave and get back in on F1, then you'll have to leave and come back in again on H1, because they will not change your status for you automatically again on October 1. Again, these are complicated intricacies. If you have questions or concerns, give me a call. Let's talk about the substance of the H-1B. The H-1B, in order for it to be approved, you need a job offer. The job offer must require at least a bachelor's degree, and the employer must pay you a certain prevailing wage that the Department of Labor sets. And the initial step from the employer is to obtain something called a labor conditions application. And the labor conditions application kind of just sets out the what is the job, what is the job title, what's the classification, what's the salary they're going to pay you, is it full-time, part-time, where is it going to be? It's very heavily regulated, and all that has to be disclosed. Then after the labor condition application is certified by the Department of Labor, then the company turns around and files it with immigration, and then this is where it must be proved that you have at least a bachelor's degree, you've maintained your status. All the things Ashley mentioned about maintenance of status must be proven up. And the immigration must be convinced the job offer requires at least a bachelor's degree. If there's any licenses required, you must have those licenses, and things like that. Okay. That H-1B initially is valid for a maximum of 3 years. You can change employers. Let's just pretend you change employers 2 years into your employment. Then at that time, you'll get another 3 years maximum. But you as an individual can only have a total of 6 years of H-1B time. And then you must leave the USA for a year before you can come back in on H-1B. Okay. Okay, I see we have some questions now. Currently, I have an approved I-140, and I am in line to file for an I-485. If in this situation I change my visa status from J1 to another type of visa, such as H-1B, will there be any issues for me? So probably not. And if you had a lawyer file all of those things, I would ask your attorney. But typically, it's okay, and there's really no problem to do that. It's important that if you went the other way from H-1B to J1, that could potentially be a big problem, because you could make the 2-year foreign residency requirement come into effect again, even if you've gotten it waived before. So probably there's no problem changing non-immigrant visa statuses, but the other way around to J1 would be a problem. Okay. I have an H-1B visa and my I-140 is approved in the EB2 category. Can I move to the EB1 category to speed up the process? Yes, you can. Since you're on H-1B and you have an I-140 approved, that means you no longer have the 6-year limit of H-1B. And you can change to the EB1 category, and that will, change your priority date on the visa bulletin that I showed earlier. And so I'm assuming you do not have an I-485 filed yet, but it'll permit you to file your I-485 sooner. The visa bulletin chart that I showed earlier changes every month. Every month there is a new visa bulletin and the timeframes change. Every year, the law permits immigration to infuse new numbers into their quotas. Immigration in the government's calendar year resets October 1, not January 1. So the October visa bulletin of every year is very important and gives a lot of good predictions for the next year. Okay, next question is, I am now the J1 researcher subject to the 2-year rule. I'm clear that if I plan to stay in UTSA for a longer time, I just need to extend my DS 2019. Well, one question is that if I finish the program at UTSA and would like to find another postdoc position in the US, what should I do to apply for another J1 visa within the 5 years limit? Okay, Ashley, you want to handle this one?
Sure. So that's a great question, Lulu. As long as you have not used up all 5 years, then it's pretty simple. If you, let's say you're at UTSA for 2 years and you get offered a postdoc position at another university, it can be a simple CVIS transfer. So basically, you would just let us know of where you're going to be going. We will have the responsible officer or the ARO at that other university complete a form, basically indicating what you're going to be doing there, when you're going to have the start date there, so that way we know when to transfer your CVIS record. Essentially, they will issue you a new DS 2019. The CVIS number will remain the same. You'll still be a research scholar. You'll still have the 5-year limit, so you'll be able to use the duration or the remaining time that you have not used with UTSA there. Now, if you end your program at UTSA and you leave the United States, and let's say you get offered another postdoc position somewhere else, now that's going to be an issue because you won't be able to come back as a J1 research scholar for 2 full years. And this is separate from the 2-year home residency requirement. So this is a 2-year, 24-month repeat participation clause. So you would be unable to come back in that category for 2 full years. The only way around it really is if you come back as a J1 short-term scholar, which has a maximum duration of 6 months. Or if, well, you are subject, so if you got waived, you could potentially come back as an H-1B as a postdoc too, because we have many H-1Bs that are postdocs. But as long as you're within the 5 years, you can transfer easily. And if you have questions about the transfer, just let me know. Happy to help you with it.
Okay. So, by the way, I mean, about the transfer, specifically, should I apply for another visa from China, like, or just
No, you don't.
some?
You don't need a new visa. So as long as you're in the United States, you don't need to leave. Even if your visa has expired, it only needs to be valid when you are traveling to the United States. So if you were to depart to go on vacation, then of course you would need to renew your visa before coming back.
Yeah, I know that kind of the visa is a ticket to visit the US, but during after the 2 years, maybe I will have some meeting outside the US. So which means I need to depart. I need to left US and then come back. So then, from that kind of aspect, should I have another new visa, right?
Yeah, if your visa has expired and you go to, let's say, a conference abroad for, a week or whatever, you would need to have a valid J1 visa to come back. Unless your travel is to Canada, Mexico, or the adjacent islands minus Cuba, you could potentially come back on automatic visa revalidation if it's less than 30 days.
Okay. Okay, thank you.
I think that's all the questions.
Any other questions? And if you don't want to ask your question, that's fine. You can give me a call. We can set up a time and discuss your particular situation. The initial question that we got before we kind of started the presentation, maybe we can touch on that one again. But it's going to revolve around the 2-year foreign residency requirement. If you have that, then that's obstacle number one. And if you don't, then typically you're going to get on H-1B. The next challenge is going to be the 6-year limit. And the goal is going to be to file an EB-1 if you're born in India. If you can't file the EB-1, then file the EB-2. It's fine because you need an I-140 approved. Otherwise, you're going to have to go back home. And then you can file the EB-2 today and file the EB-1 tomorrow. Once you do become, qualified for its eligibility. And that's basically the roadmap if you're seeking a green card through the employment-based method as a researcher. And so as a researcher, you have the EB-1B category, you have the EB-2 national interest waiver category, and you also have EB-1A as an extraordinary researcher or extraordinary ability as a researcher. There's a few options available. And if you're in the private industry, they can do a regular perm for you as opposed to national interest waiver. If you have an employer that's qualified and able and wanting to do perm for you, then by all means take it up. It takes a long time. It's about a 2.5, 3-year process these days with Department of Labor to USCIS to green card. But once you get permanent residency, then you can work anywhere you want. You can kind of do anything you want. It's one step short of US citizenship. And then after you're a US citizen, that completes your immigration life cycle. Any other questions?
Thank you, both of you. And I will just stop the recording and we still have 10 minutes if they want to ask more question. Again, thank you both. And Mr. Wallace already forwarded those slides. So if you are interested, I can forward you all. And also this recording will be on our graduate school YouTube channel. So you can hear them back. If you have any question, you can reach all of us. I'm Madhumita. I'm Director of Postdoctoral Success. Mr. Wallace is a Director of ISSS, and Mr. Shahid Malik is a lawyer. His information is there. So you can reach all of us or any of us. I will forward your email if I receive any question. And thank you again for joining. And we still have 10 minutes. If you have more question, I'm stopping the recording.